Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. Several of the motions in limine, which traditionally and typically have to do with evidence that may or may not be brought into the case at trial, and where in limine, this is pre-trial, one party or the other is seeking a ruling from the court outlining what evidence the jury may be authorized to see, to hear, to know about. Besides that, we've seen several filings from both sides addressing language that they're asking the court to prohibit the other side from using. For example, in state's reply to defendants' response to their motion in limine filed the 21st of March 2025, the state is outlining what it feels are improper DP comments they claim the defense have made and should not be able to make to try to elicit an emotional response from the jury. The state here says that it brought this motion, and that's a motion in limine, ladies and gentlemen, based on defense counsel's, and they're saying, repeated references to the, quote, state attempting to unalive, beginning with the K word here, their client, which only serves to improperly incite the emotions of the jury, according to the state. The state continues and says it has a statutory right and cites to Idaho Code 18-404A as an apple, which it has chosen to invoke to seek the DP in this capital case, ladies and gentlemen. And going on to page 2 of this filing, the state continues. Invoking this right does not open the door to the use of inflammatory language in front of the jury. The state seeks an order in limine, ladies and gentlemen, to prohibit the defense counsel from stating, quote, the state has decided to attempt to unalive client Mr. Koberger in brackets, or the state is trying to unalive one of us. Phrases that have been used in previous hearings as cited in the state's motion, or similar phrases. And then it goes on to the next paragraph. The state relied on Idaho criminal jury instruction 700C as in Charlie in its motion to illustrate that such language is inappropriate during the guilt phase, when a juror is instructed not to, quote, concern yourself with the subject of penalty or punishment, end of quote. And then the state argues that this particular jury instruction, 700B as in boy, instructs the jurors that this is a capital case and describes the process for sentencing if the defendant is convicted of unaliving. The state understands the jurors will be advised that this is a capital case, and it is in no way suggesting that this fact be withheld from the jurors. But this fact should not permit defense counsel to characterize this statutory right in any manner they want, i.e., using inflammatory language with the purpose of inciting an emotional reaction from the jurors. For the above reason, the state's requesting here that the court prohibit defense counsel from making any reference to the state, quote, attempting to unalive the defendant or similar phrases. And this is signed 21st of March 2025 by Ashley Jennings. She is the senior deputy prosecuting attorney in the matter styled as Idaho versus Koberger. This will now conclude this episode of the Indie Zone podcast. My name's Kathy. Thank you for joining us here today.